Welcome, everyone, to another installment of our podcast here from the spectacular Broward County Bar Association studios. This is Workplace Matters. My co-host, Diana Castrillon.
Hey, everyone.
And we have a very, very special guest, somebody that if you saw a podcast that was taped in February, was it?
I
March?
believe so, yep.
You'll know him. If you didn't see the podcast, I'm sure you'll recognize his face. It's Richard Chait.
Good afternoon.
Thanks for being here, Richard. And, this was supposed to be part 2 of our legislative preparation. This was supposed to be now the kind of legislative update as to what happened.
Wrap up.
The wrap up. But here's what's better, I think, is this is not going to be just part 2 and done. We've been talking to Richard, and he's been so courteous as to lend us some more of his time. And we're going to actually continue to keep all of you updated on legislative topics throughout the course of the year and on the lead up to the next legislative session, because we'll learn shortly, this wasn't so black and white.
Right.
And we're existing in the gray. And so why don't you tell us a little bit about exactly what happened during this legislative season?
It'll be my pleasure. I did make a promise during the last podcast that I would come back post-session and we could do a wrap.
Promises made, promises kept, right?
Promises made, promises kept. That's definitely my style. However, where I would normally start with, we sine died last Friday and the legislative session for 2025 has concluded. I'm not in a position to suggest that today. If you have been following either the news or any of the other podcasts or social media, it should come as no surprise. This was a very unique legislative session. There is so much volatility between the governor and the House of Representatives and the Senate that it is very difficult at this point to predict when we're going to bring the 25 session in for a landing. They had to extend it. They had to extend it, most importantly, because budget negotiations are still underway. But at the same time, when a session is extended through acquiescence between the Senate and the House of Representatives, bills are still in play. And I'd like to suggest, and I would like to believe, that they're going to be budget-related bills, and that most, if not all, of the policy-related bills have essentially been suspended and will ultimately, and more than likely, be picked back up when we resume for the legislative committee weeks at the end of this year. You can't say that with certainty.
When are we extended till?
So what the legislature has done is they have extended the session as opposed to having the governor call a special session. They've extended the session till midnight on Friday, June the 6th.
Okay, so we're in session now.
We are in session now. The members took this week off, I think, just to go home, let some of the steam subside, come back with a fresh set of thoughts and approach. And so it will be resuming again Monday morning on the 12th, following the Mother's Day weekend.
So this overtime session, right? Let's just call it that, right? This is like the fifth quarter of a football game. Is everything in play, or are they just going to focus on the budget?
Well, nothing has been set in stone, but I can let the audience know that I firmly believe that with respect to what our primary concern was, what the genesis for this podcast is with regard to the opt-out, House Bill 1069 and Senate Bill 1426, I think that I can firmly advise that they have died for purposes of the 2025 session.
Never been so happy to hear that something is dead as I am to hear about those two. But it's interesting because when we did meet in February, we were talking about potential bills, something that might exist,
we didn't even have numbers or anything.
And here we are just a few weeks really later, and we're talking about House bill and Senate bill, and there were numbers next to each of those words, which means these bills actually were created, went through committee, and existed as actual bills that could have essentially eliminated workers' compensation law from the statute. So if you can give us a quick recap of just what these bills stood for, because even though they are effectively dead, as you've said, as we all know with workers' comp, this is maybe just one of many steps towards future legislation. So quickly describe those bills for us, if you would.
I will do that, Diana. I do, though, want to get back to how we ultimately landed.
Yeah.
But let's jump into that. So with respect to House Bill 1069 and Senate Bill 1426, these were filed by seasoned representatives and senators of the majority, the supermajority party. This was not something to be taken lightly. The House bill was filed by Representative Tom Fabricio, and the Senate bill was filed by Senator Nick DeSigli. Again, these are not freshman legislators. These are legislators who move legislation, move their bills, get certain priorities. And so that in and of itself was a concern in terms of the first shot that was fired across the bow. These bills, when I read them, and they're identical, so you would call them companion bills. And that's the other thing, is that when you have legislation in the House and the Senate and there are companions, that enhances the likelihood that bills are going to pass. If a bill was filed in one chamber but not the other, then it's highly unlikely that we're going to be facing the consequence of this type of legislation. So
is that just because there's just not enough time to reconcile the competing bills, or what? I mean, just real. I'm a little bit of a wonk with this stuff. I'm just curious. What's your take on that?
The question being, why do you need a companion bill?
No, the question is, when you have, you made the statement that these bills were identical, which favors passing.
Correct.
Right? But when bills, same subject matter, but are different, what's
well, then there needs to be mandatory processes either in committee or on the floor of the House or the Senate, where ultimately one of the chambers is going to have to acquiesce and accept the version coming from the other chamber for them to line up and be identical before it can pass legislation and be sent to the governor.
And that way we're clear. That's not what we're dealing
Correct.
with.
Right. Frighteningly, we had a united front, which is, when do we see the House and the Senate agree on something? Unfortunately, it had to do with making us go bye-bye, so.
That's what was so concerning, is that there weren't any abilities to distinguish one through another and potentially create a wedge that could stall and or create a disparity where you can essentially kill it that way. We were looking at identical bills. So in terms of what these bills included, and I strongly encourage everybody to go on either the House of Representatives website or the Senate of Florida website, and you can basically work through the surfing mechanism. 2025 legislative session, all you need to do is type in the bill number, which again, House Bill 1069, Senate Bill 1426, and take a read. Because when I first read them, it was one of those, and I don't know how many of you practitioners have been around long enough where you remembered managed care, where you would fight to get authorization for a specific doctor, and then you would be sent a list of medical providers. And I remember I'd look at that list and I'd be like, oh my, I can't pick anybody from this list. And I'd put it down and I'd move on to something else and think maybe when I came back and looked at it a second or a third time that it would get better. This never got better, okay? This was highly concerning. But not just for injured workers and the claimants bar. And that's really the message that has to be resoundingly understood, not just today, but moving forward, because I have been told by the Speaker of the House that we cannot become complacent. Yes, we were successful this year. In fact, this was the first time that I could say was an outright win, which goes a long way toward suggesting we have developed, after much wear and tear and years of turbulence, we have developed the optimal successful model. But that model must be sustained. That model must continue to be enhanced. And when I'm being told by the speaker that we cannot become complacent, that's all I need to know. People need to realize this is a systemic attack on the entire industry. If your business model is dependent on the Florida workers' compensation system, then this opt-out type legislation is just, it's as draconian as you can imagine. It is devastating. With respect to the employers, my biggest concern is that this provides a mechanism that would allow for the long-standing immunity shield to be eviscerated. And literally, the proposed legislation allows for the injured worker to opt out. It's not just the employer that can opt out. The injured worker can opt out and file a tort suit.
And for those who may not know what the distinction is, and I know that we've called it, although I've never seen it in any piece of legislation, we call it the grand bargain, right? So how is our current system different compared to what you just described in these two bills that were filed by the
So the grand bargain is the fabric for the Florida workers' compensation system. It was the genesis for the due process argument of our Castellanos case that was opined on April 28, 2016, which, by the way, took from 2009 to 2016 to be established and determined as unconstitutional. Okay, so that's another concern, is when you look at these bills and on their face, I believe and I advocated they were unconstitutional. Our system cannot afford another 7-year delay to prove that the bills are unconstitutional. When you get to the grand bargain analysis, what happened with respect to the grand bargain is that it was a historic agreement where workers gave up their right to sue employers in tort in exchange for a guaranteed provision of medical care and wage replacement.
That's our current system.
That's the current system. It's also a system that has been dismantled over time through legislative reform, through court opinions. And so essentially, the grand bargain is already teetering on a tightrope. This would basically not just blow it up, but it would allow for it to be completely ignored. And you could essentially elect another mechanism that would be adequate for purposes of providing workers' comp coverage, which the state mandates for the most part, unless, there's few exceptions. And so this would not only allow for an end around to the grand bargain, but it would allow you to implement an entire new system.
And it's interesting that you talk about how this impacts both sides of this of the workers' comp world, and all stakeholders outside of just claimants and defense in these cases, because if the claimant can opt out as well, then this is exposing employers to being sued in tort.
Well, that's the concern from the employer side.
From the employer side, right. So, what's interesting about these laws that we're talking about, and some people may be looking at this and going, hey, if these laws died, why are we still talking about them now? Why are you dedicating a series to talking about laws that don't exist right now? And the reason why is because, as we all know, in 2003, there were very significant changes that occurred in our statute, but those changes were first proposed in the 90s. So what does that mean? That means that this is the first time that we're seeing this proposition. But as we know, historically in workers' compensation, this is not the last time that we're going to see some sort of opt-out bills being proposed. So having members on both sides of workers' comp understand the ramifications of these opt-out provisions, I think, is very, very important. This is one time when I feel like we're very united in presenting opposition to a law. So the House and the Senate came together to propose one horrific bill. Well, now the claimants and the employer carriers need to truly come together in responding to these
If
bills.
I may, because we addressed this last time. The House and the Senate did not propose these bills. Okay?
Right.
Individual members
Right.
of the House and Senate proposed these bills. Okay? The leadership of the House of Representatives and the leadership of the Florida Senate actually recognized and accepted the advocacy and the arguments that were made that indicated this was bad policy and that the workers' comp system was in good standing, that, as we discussed last time, rates have cumulatively declined since that 2003 reform, 78%. That included not this past session, but the 2024 session, allowing us to substantially increase the medical fee schedule to hopefully bring in better doctors to afford higher quality of care and have additional doctors available to shorten the life expectancy of these cases so there weren't delays to see specialists. And even with that increase, rates still went down 1 additional percentage point from 77 to 78. I'd like to thank specifically the Speaker of the House, Danny Perez, our Speaker Designate, Sam Garrison, our Commerce Chair, James Buchanan, the entire Insurance and Banking Subcommittee, and specifically Representative Michelle Salzman and Representative Bernie Jock, with respect to how we were able to kill this legislation in the House. In the Senate, clearly we owe a tremendous debt of gratitude to the Senate President, Ben Albritton. Senate President-elect Jim Boyd was a champion. He and I worked together along with our lobbying team of Converge to have this thing postured in a way where it did not gain traction. And specifically 2 senior ranking senators, Senator Joe Gruters and Senator Jennifer Bradley. Very important to realize all of them are from the majority Republican Party, super majority Republican Party, and that's really the dynamic of how far we've come to be able to sit down and have reasoned, sound discussion with legislative leadership. These bills were killed with leadership. These bills essentially were killed where they sided with us and our policy arguments and went against senior representatives and senators from their own chamber.
And that doesn't happen easily.
That has never happened before.
And obviously we have a huge debt of gratitude to give to you specifically and to everyone who has assisted you in getting to a point where these folks are listening to what workers' compensation means, understanding workers' comp legislation. People didn't understand. The folks, in Tallahassee really didn't understand workers' comp. So I'll thank you on behalf of the Claimants Bar, and I'm sure Henry thanks you on behalf of the Defense Bar, because quite frankly, the fact that we're still working right now and having this conversation is in no short part to a lot of the work that you did. So obviously, thank you very much for all of that.
Bad policy. At the end, that's basically what it was, irrespective from me anyway.
For
whether
sure.
whether you claim it, defense, mediator, court reporter, interpreter, transportation company, nursing case management, whatever. Like you say, if your business model depends on the viability of workers' compensation in Florida, you are, quote unquote, a stakeholder in what we're talking about today. The bad policy is bad policy.
Here's the concern, though. You need standing. Just like in a legal matter, you have to have standing, okay? My perspective requires that I have to have standing to be able to have the conversations with the appropriate legislative leadership to be able to advocate that this is bad policy. Because there are thousands of bills that are being floated. And if you don't have a forum, if you don't have an opportunity to be recognized and trusted to advance the arguments, it can be bad policy and it's not going to matter, especially when a system like this is often controlled by special interests. And let me tell you something, this Texas Q-Care model is an interest group who basically is not going to go away and has legs and has money and has hired one of the premier, most powerful lobbying firms that's president and CFO is a former Speaker of the House. And what I did learn is they don't care about the policy. They're just focused on if a client is going to hire them, they are going to promote the objective. And that's the big distinction between dealing with the legislative and political arena and dealing with jurisprudence in the court of law.
And we know that these special interest groups, even now that session is coming to a close, notwithstanding the budget remaining open, they're continuing to gather funds. They're continuing to gather lobbying interests and lobby groups because Q-Care and these opt-out provisions are not going anywhere. So that's the reason why we've extended this into a few different podcasts, because we need to dive deeper into what Q-Care looks like, what the opt-out world looks like, and talk more about what's happening on the off season, because we know from experience speaking with you, Richard, that so much happens during the off season when we're not in session. That's when a lot of stuff is happening. And so we're hoping to keep everybody in the workers' comp world apprised as to the off season process.
Everyone needs to weigh in, okay? I appreciate the thank yous and the accolades. And look, I did not anticipate when my law firm won the Castellanos case that I would never be in a courtroom again and I would have to immediately transition into doing this full time. I recognized there was a need, and the Florida Workers Advocates recognized there was a need for somebody to do this full time that could build relationships, that could establish credibility, and as we were discussing, have a forum where you could have healthy dialogue and be trusted when you say this is bad policy. That's what I do. That is what I do 24/7. And when I say 24/7, I'm not underestimating that. I can get a phone call at 11 o'clock at night, and for the next 2 to 3 hours, that's going to be the most important thing that I have to do for the next week. That's the way it works. It's not driven by the type of schedule and confines of the litigation practice. We need to raise political funds. I am very sorry that is the grim reality. That is the grim reality, okay? And there is a mechanism for everyone to do it. Henry and I worked on it so that when we kept facing scenarios where defense attorneys, mediators, different practitioners in the system that are vendors or special operators that did not want to risk compromising with respect to supporting the Florida Workers Advocates, FWA, we have now come up with a mechanism under what is called honest leadership. It is a political committee for future Speaker and Speaker designate currently Sam Garrison, who will be the next leader in the House of Representatives, who is on all fours with Speaker Perez. In fact, I thanked him earlier when I was doing the acknowledgments. And this is what we now need to do, because every 2 years, there is a shift in power. And so when you couple that the Speaker himself has told me that our organizations cannot become complacent, that this is not going away. When my intel has told me that these special interest groups are looking to hire multiple lobbyists to conflict out lobbyists so that when interest groups that are also impacted by this realize, Houston, we have a problem or a potential problem and we need a voice and we need to retain lobbyists, well, there's not going to be a lobbyist to be had. We need to get out in front of this now. We need to be proactive. That's what this off season's going to be about.
All right. Well, we look forward to hearing more at the conclusion of this session and then what happens, during this off season. And we're hoping that in the next few months, we'll be able to sit down with you again and hear a little bit more about some additional game plans. And I believe that for today, we've concluded our podcast. I want to thank you once again for being here with us, Richard. And
Yes,
we look
thank you.
forward to what you have to tell us soon.
Thank you.
Thank you, everyone. Trust the process. Trust the model.